Welcome to An Ounce of Prevention, the podcast. At our Reese Associates, we believe that an ounce of prevention is worth a pound of cure. Our daily commitment lies in informing our clients about legal risks without hindering their business objectives. As we like to say, we're in the business of building companies and helping executives sleep at night. So stay tuned. Maybe you'll learn something that'll help your business grow and thrive.
Welcome to An Ounce of Prevention, where we believe an ounce of prevention is a pound of cure. I'm your guest host, Miranda Caballero. Before I explore 1031 exchanges, let's take a quick look at a recent case law update and break down what it means for your business.
And now it's time for another case law update. Our next case law update covers the WorldVue Connect Global LLC versus Zouch case in the Fifth Circuit originating out of Texas. This case involved a dispute over the breach of a non-solicitation and a non-compete provision in a contract. Here's what happened. WorldVue provides customer support services ranging from entertainment systems to Wi-Fi for hotels and their customers worldwide. Jason Zouch is the owner of international and domestic hospitality support businesses. Zouch owned Hospitality Wi-Fi, which he sold to WorldVue Connect in 2022. As part of the agreement, Zouch received a minority interest in a new company, WorldVue Global. Part of this transaction included the transfer of a highly trained customer support team and the transfer of Hospitality Wi-Fi's confidential information. Fast forward to 2024, and the business relationship between WorldVue and Zouch broke down, resulting in a settlement agreement in which WorldVue agreed to purchase Zouch's interest in WorldVue Global, and Zouch agreed not to compete with WorldVue or solicit members of WorldVue's workforce for 1 year. Specifically, the non-compete provision stated that Zouch and his related groups and businesses, the Zouch parties, would not solicit or recruit employees or independent contractors of WorldVue in a restricted area that included the United States and Canada. As a remedy, both WorldVue and the Zouch parties agreed that the non-compete and non-solicitation provisions could be enforced by an injunction. Additionally, the disclosure of confidential information would entitle a party to injunctive relief. On the same day the settlement agreement was signed, members of the Zouch party sent emails and messages around a work chat discussing WorldVue employees in the restricted area that the group wanted to recruit. 2 weeks after the settlement agreement was signed, the Zouch parties recruited 4 employees who provided services in the restricted area. A month after the settlement agreement was signed, WorldVue sued the Zouch parties for breach of contract, seeking a preliminary injunction to stop the Zouch parties from recruiting WorldVue employees. The district court in Texas granted WorldVue's request for a preliminary injunction. The Zouch parties appealed. On appeal, the Zouch parties argued that the district court committed 3 errors. 1. The district court wrongfully interpreted the settlement agreement to include solicitation of employees who live and work outside of the restricted area. 2. The district court erred in considering WorldVue's workers to be employees or independent contractors, as they were employed by a third-party agency. And 3. The district court incorrectly concluded the Zouch parties used confidential information to recruit the workers from WorldVue. In response to the first argument, that the district court had wrongly interpreted the non-solicitation clause to include employees who live and work outside the restricted area, the Fifth Circuit upheld the district court's injunction. Under Texas law, contracts are interpreted by their plain language. The court determined the plain language of the non-solicitation clause included employees whose jobs were supporting networks in the restricted area. While employees themselves might live and work outside of America and Canada, they still provided support in these 2 countries. The employees were within the plain language meaning of the non-solicitation provision. In response to the second argument, where the Zouch parties argued that the WorldVue employees were not employees or independent contractors, but rather employees of a third party, the appellate court agreed with the district court's ruling. The court wrote a short comment stating, agents can be both employees of third-party agencies and independent contractors of WorldVue. The Zouch parties breached the contract by attempting to recruit WorldVue's independent contractors, so the district court was correct in issuing a preliminary injunction. In response to the third argument, that the district court incorrectly concluded that the Zouch parties used confidential information to recruit workers from WorldVue, the appellate court agreed with the Zouch parties. The Zouch parties argued that information about workers' identities, compensation, and skill level is not confidential. Instead, it was general knowledge that Zouch obtained before working with WorldVue, as Zouch himself went to dinner and traveled with these employees. He obtained personal knowledge about these employees rather than confidential information. WorldVue argued argued that because it had purchased Zouch's knowledge, it now owned that knowledge, and so Zouch could no longer use it. The court held that Zouch's personal knowledge about the employees, which he obtained before WorldVue purchased his company, was not confidential information, as defined in the contract. However, the information about compensation, skills, and value after the 2022 transaction is considered confidential, so Zouch is enjoined from using post-2022 information. Under Texas law, to obtain injunctive relief, the party must show irreparable injury. It has long been held that injury resulting from the breach of a non-compete covenant is irreparable injury. WorldVue properly showed evidence of irreparable injury to their business as the Zouch parties breached the non-solicitation and non-compete provisions of the settlement agreement. Overall, the Fifth Circuit upheld WorldVue's request for injunctive relief against the Zouch parties poaching their employees, with a slight modification to the definition of confidential information, excluding Zouch's personal knowledge of personnel. So why should you care? This is a classic example of a good deal gone bad. When that happens, it's so important to look closely at what each party knew and had access to track what was done inside and outside of your systems, and distinguish between what is and is not confidential information. That's it for this case law update. I'd like to thank Frances Warden, a law clerk in our Denver office, for her help with this update. I hope you found this episode informative. Thanks for listening.
Today, we're talking about Section 1031 exchanges, a powerful but sometimes overlooked tool for oil and gas investors. If you've ever sold a producing asset, mineral interest, or working interest and wondered whether you could defer the capital gains tax, this episode is for you. Section 1031 of the Internal Revenue Code allows you to defer capital gain taxes when you exchange one like-kind property for another. In oil and gas, that can include fee minerals, producing leases, overriding royalty interest, or working interest, so long as both the property you sell and the one you acquire qualify as real property under the IRS definition. For many landowners or small operators, 1031 exchanges are a powerful way to transition from active operations to passive income, or to move from one basin or state to another without triggering a big upfront tax bill. The IRS considers all U.S. real property to be like kind. So a working interest, a royalty interest, or even a leasehold can qualify if it's considered real property. The tricky part is distinguishing between real property and personal property. For example, equipment, production facilities, and intangible contract rights usually don't qualify. But leases, minerals in place, and royalty rights typically do. Company stock and equity interest also aren't going to get you there. State law classifications of real property interests can also create some issues. The first step is always figuring out what's in the deal and what counts as real property. The IRS has strict rules. Once you sell, you cannot touch the proceeds. They have to go straight into the hands of a qualified intermediary. Someone who meets the IRS requirements for a qualified intermediary and is not a disqualified person as defined in the Treasury regulations, such as your attorney, accountant, broker, related party, or family member. The intermediary holds the money and makes sure the exchange stays compliant. Our RNA commonly works with qualified intermediary service companies that play this vital role. There are two primary rules in 1031 transactions. Under the 3-property rule, you can identify up to 3 properties of any value as long as you close the deal within the 180-day window. Alternatively, under the 200% rule, you can identify any number of properties as long as their combined fair market value doesn't exceed 200% of the value of the property you sold. You have 45 days to identify your replacement property in writing to the qualified intermediary. That's a quick timeline. And 180 days to close the deal. Miss either deadline and the whole exchange collapses, which means you owe taxes. It is important that your purchase and sale agreement or other definitive agreement adequately addresses a party's ability to carry out the transaction as a 1031 transaction. The language should allow either party to structure the deal as an exchange without delaying closing or shifting any liability. But remember, each party is responsible for their own tax planning. Just because the clause is there doesn't mean the IRS is going to bless your transaction. Of course, 1031 exchanges come with challenges. First, title complexity. You're often dealing with fractional interest, multiple lessors, and layered ownership. Whoever is the named entity or person selling the property must be the same person or entity acquiring the 1031 exchange property. Second, valuation. Like we talked about before, you have to allocate properly between real property and personal property. And third, timing. Let's be honest, drilling schedules, regulatory approvals, and environmental due diligence can delay closings. That's why it's important to use a qualified intermediary and advisors who understand both the tax code and the energy business. So here's the takeaway. A 1031 exchange isn't just a tax trick. It's a strategic tool. It lets you defer taxes, preserve capital, and reposition your assets in smarter ways. Maybe moving from mature fields into developing plays, consolidating acreage, or simply diversifying your portfolio. Done right, it can even defer taxes indefinitely through estate planning. For example, one of our clients sold a small working interest in the Eagle Ford that had appreciated significantly. Instead of paying capital gains, they rolled the proceeds into a package of producing mineral interest in the Permian. That move not only deferred the tax, but shifted them from an active operator role to a passive royalty owner. Less risk, steady cash flow, and diversification across wells. We've also seen families use 1031s to consolidate smaller fractional interests into larger, easier to manage holdings before succession planning. If you're considering selling or buying oil and gas assets, think about 1031 exchanges before you close. And as always, consult with RRNA early to get good advice and find the right qualified intermediary. That's it for today. Thanks for listening. And remember, in oil and gas, building wealth isn't just about the wells you drill, it's about the strategy behind the deals you make.
Greetings, ghouls, ghosts, and most importantly, deal makers. If you're heading to Houston this October, mark your calendars because you won't want to miss this. Join us on October 23rd for RRNA's inaugural Dealmakers Haunted Hall Halloween Gala, where the A&D community comes together for a night of networking and meaningful impact. Now, if you are looking at the calendar, you already know that this week is packed with high-caliber events. There's the SPE Annual Technical Conference from October 20th through the 22nd, the Minerals and Non-Op Assembly on October 21st, the North American Capital Assembly on October 22nd and 23rd, and of course, the Women's A&D Luncheon on the 23rd. So why not cap off the week in style with our event the night of the 23rd? Tickets are on sale now, and if you won't want to miss this eerie evening of industry magic. Bringing your deal-making team? Go for the squad ticket. Just $1,000 for 6 tickets, perfect for teams, friend groups, and partners in crime. Visit www.rreeselaw.com to secure your tickets before they vanish into the night. There are also still sponsorships available. Interested in sponsoring this year's event? We'd love to have you on board. Visit our website for details or reach out directly to explore how you can be part of the magic.
The information and material in this episode is general information about our practice and firm and is for educational and informational purposes only. This information does not offer specific legal advice, and the use of this information does not create an attorney-client relationship with RRNA or any of its attorneys. The information in this episode, or any episode of An Ounce of Prevention, should not be considered legal advice, and persons should not act upon this information without first engaging professional legal counsel.
Thank you for listening to An Ounce of Prevention, presented by Reese Associates. If you found this episode informative, subscribe to, rate, and review our podcast on Spotify, Apple Podcasts, YouTube, or wherever you listen to stay up to date with future episodes, case law updates, and breaking news. If you have any questions or are interested in learning what RRNA's outsourced legal department can do for your company, reach out to us at podcast@rreeselaw.com. That's podcast@rreeselaw.com. Follow us on LinkedIn or call 832-831-2289.